DroneLaw.Pro Radio. We are here today with Sarah Nillson, and Sarah has been a pilot since 1994 and a flight instructor since 2000. She is the Assistant Professor of Law at Embry-Riddle Aeronautical University. She is a FAST team representative for the FAA and the founding attorney of Nillson Law PLLC, specializing in aviation and space law. Sarah, welcome to the program.
Thank you for having me.
So today, Sarah, we want to talk a little bit about the December 17th fact sheet that was issued by the FAA concerning preemption, the relationship of state and municipal laws with the FAA's jurisdiction and regulatory framework. Give us a little history here, Sarah. What do you think the FAA is trying to accomplish with this December 17th fact sheet?
Well, first of all, the general public may or may not know, may not be aware that back in the early beginnings of manned flight in this country, the FAA was created to be the sole jurisdiction, I guess, for airspace over the national airspace over the country. And so with the FAA Act of 1958, the FAA was given that role. And the primary reason was for the safety and efficiency of the use of this airspace because of the increase in air traffic. Ever since then, it has been up to the FAA and the FAA alone to make regulations pertaining to this airspace, and there's a ton of it. However, lately, with the advent of unmanned aircraft and the proliferation of all these in the sky, states, cities, and local municipalities have been taking it upon themselves to enact laws. And I can see where they did this, because the FAA's rule regarding small UAS for commercial use has yet to be published. And so I guess impatience led to everybody doing their own lawmaking. And this flies in the face of preemption, because the FAA has the sole field preemption of this airspace. And so anything that's made that conflicts with this federal rule is really not good law. And this is why the FAA chose to put this out, because of the increase in states and municipalities doing their own thing.
Yeah, it seems like there's a little bit of hysteria every time there's a new emerging technology that is released into the public, and with drones we're certainly seeing that, where you've got a lot of people having some overreaction to the fact that drones are flying in the sky. The FAA, in their fact sheet, they say states and local jurisdictions are increasingly exploring regulations of UAS or proceeding to enact legislation relating to UAS. And they really hit on the safety issue. They say that the reason that the FAA's got jurisdiction here, and essentially they're trying to back the state and municipalities off, telling them you shouldn't be enacting a lot of these laws and ordinances that we're starting to see. And they say a consistent regulatory system for aircraft and use of airspace has the broader effect of ensuring the highest level of safety for all aviation operations. And they say that throughout the fact sheet, that the reason they don't want states to try and regulate some of these issues, or municipalities, is because it's unsafe. Now, on the state and municipality side, they think that they're actually trying to enhance safety, and the FAA is saying no. Every time you enact a ordinance or statute that interferes with FAA jurisdiction, you're actually making things unsafe. Isn't that interesting?
Yes, actually, there was a case back in 2012 which has a piece of language in it that is very pertinent to what's going on today, actually as of yesterday in Los Angeles, California. And I'm going to quote directly from this case. It says, where Congress occupies an entire field, even complementary state regulation is impermissible. And this is because of field preemption, because wherever the FAA has the entire field for jurisdiction purposes, that means that anything that is even complementary to it is not allowed. And just as a case in point, this ordinance out of LA, which came out in October of 2015, mimics verbatim almost some of the FAA regulations, so that would make it complementary per this for this language, and even that is impermissible. And yet yesterday we have someone with criminal charges, facing criminal charges for breaking this ordinance.
Yeah, you pointed this out to me, Sarah, this morning. I had not seen it yet, but it's a Los Angeles Times article, and it says LA City Attorney files first criminal charges under new drone ordinance. So the LA drone ordinance now has been in place for a little while, and essentially the ordinance tries to mimic the FAA regulations, which on its face might seem, well, okay, that's okay, right? The FAA is saying, no, that's not okay. We have jurisdiction, you do not. We get to determine both enforcement and interpretation of these rules. And so you've got two men accused of flying drones within the vicinity of a hospital, and police heliports will be the first to face criminal charges under the new LA drone restrictions. And based on the fact sheet, Sarah, what do you think the odds are of the of Los Angeles ordinance being upheld at the lower level and then on appeal?
Well, probably on the lower level, I don't hold out very much, but on appeal, definitely. The case that the defense should be bringing in is that let's see, we've got Arizona versus US from 2012. We have French versus Pan Am from 1989. And then we have Montalvo versus Spirit Airlines from 2007. All those cases talk to the field preemption. All those cases talk to where when Congress occupies an entire field and gives that over to the FAA for their jurisdiction, any complementary state regulation is impermissible. And the fact sheet actually goes on page 3 to cite this very instance as an example for where state and local laws need to consult or must consult with the FAA. And it talks about operational US restrictions on flight altitude, flight paths, operational bans, and any regulation of the navigable airspace, which this ordinance has all of that. And it cites as an example city ordinance banning anyone from operating US within city limits, within the airspace of the city, or within certain distances of landmarks. And then it reiterates federal courts strictly scrutinize state and local regulation of overflights. And then you've got some more case law there from as far back as 73 to back that up with the field preemption even more.
Exactly, and this concept of field preemption. I mean, I as an attorney, I'm sure you heard it before as well. It would, people have this kind of generalized knowledge of preemption and say, oh well, no, states can legislate. As long as they're not negating a federal law or rule. And there are preemption doctrines which allow states to work in concurrently with the federal government. But when you have this concept of field preemption, that's a much more restrictive type of preemption, and that essentially says that, when it comes to the navigable airspace, the FAA has exclusive jurisdiction over that, and there's very few and very limited things that states and municipalities can do with regards to regulating that. It's retained to the FAA to determine what's best. And when you look at the examples in the fact sheet of things that the states and municipalities can't do, they can't put restrictions on flight altitude, flight paths, which is a very broad term, operational bans, which essentially you cannot fly, which is exactly what we see here in LA, and is many other statutes which are in bills that are being considered on state and local levels, and any regulation of the navigable airspace. That's very broad language, isn't it, Sarah?
Yes, it is. In fact, the FAA is trying to educate with this fact sheet. And one of the things that people need to remember is that there's something called police power, which is given to the states when it's dealing with anything to do with land use or zoning or privacy, trespass laws, that kind of operation. But those are very limited, and it's very difficult for people to maybe grasp the nuanced differences. While states are free to do any kind of zoning law, once they infringe upon airspace per se, they're kind of treading that fine line between what they can do for the purpose of zoning versus what they can do for the purpose of restricting an airspace, because that's within the purview of the FAA. And for anyone who's interested in knowing more about where we get the police power in our states, you could look to the 10th Amendment. That's pretty much where that comes from.
Right, and so there's a lot of and of course the FAA's fact sheet encourages states and municipalities to consult with the FAA, but I think you and I understand that the FAA is going to tell states that they believe that in fact an ordinance like LA is in fact preempted, and they're trying to, on all sides of the equation here with drone operations, both on the recreational, the commercial, and with regards to states and municipalities. The FAA is trying to take a very balanced approach and educate people, but what we are seeing, we are in the anarchy phase of SUAS, of UAS, and we're seeing a lot of really interesting things happen. There's going to have to be litigation to sort that out. One of the interesting cases that got filed recently is a case called the Boggs case. How does the Boggs case fit into all of this?
Well, the Boggs case is kind of an interesting case in that I'll just briefly overview it for those of our listeners. It all started in Kentucky when someone was flying their small UAS over someone else's property. And the person whose property it was being flown over decides to get a shotgun and knock it out of the sky. Essentially, Boggs was the owner of this small UAS, and he basically went to court against the person who destroyed the UAS for him. And the judge basically dismissed the case. And in fact, not only did she dismiss the case, she actually said he had a right to shoot at the aircraft, which, it's mind-blowing how people come to these conclusions. So essentially, Boggs goes to an attorney, and now the larger issue that this is bringing up, which we need some resolution to, is the question of whenever people buy property, real estate, the common law rule has always been that you purchase the land and a little bit of the airspace above it and a little bit of the ground below it. And that's been a common law issue since we started this country when we brought those laws from England. So we have this conflict of, well, you do as a property owner have some rights over your house. I mean, you can put up a flagpole, you can put stuff on your roof, and you don't need FAA permission for that. But where does the property owner's airspace, if you will, over their house, where do those rights end and the FAA's jurisdiction begins? Now, to hear it from property owners, if it's over their house, it's fair game.
Yeah.
And if you hear it from the FAA will tell you that if it's airspace from a blade of grass on up to stratosphere, it's the FAA's jurisdiction.
Right.
So we have this conflict, and this is not a new conflict. This conflict came about many years ago when manned aircraft were taking over the skies, and there was a famous case right after World War II where it's the USV Cosby case, where somebody had that very same thing happen with noisy jets flying over his chicken farm and scaring his chickens to death, literally. Yep. And the resolution never really gave a broad enough rule that everyone can apply over the national airspace. So what the attorney who filed for Boggs is trying to do is bring some clarity to the very nuanced rule between your privacy over your house and your FAA jurisdiction over same house. And it seems like this case may lead to that when it goes up the chain of appeal.
Right, and in Boggs, in his complaint, he talks about he wants the court to declare that Boggs did not violate Meredith, who was the person wielding the gun, reasonable expectation of privacy, and that property owners cannot shoot at drones operating in the navigable airspace. Obviously, the ruling could establish principles beyond shooting. Can you fly over someone else's private property at a certain altitude? And in that case, Boggs was 200 feet over the property. And so in this case, Boggs and his attorney are asking the court to declare where is that line between private property rights and his right to fly a drone in the navigable airspace. Let's say the FAA says you can fly, then the question becomes, can a property owner potentially shoot a drone down or bring an action against someone for trespassing at a certain altitude? I'm not sure how this case is going to play out, but one of the possibilities, Sarah, is that that there is this some altitude applied to private property, 50 feet, 20 feet, 83 feet, whatever it turns out to be. That's one possible approach. What do you think about what do you think is best for a court here in terms of trying to come up with some sort of test? Is it to come to an altitude or a more nebulous, reasonable type expectation of privacy or cohabitation of the sky approach? Where do you see this going?
Well, it's a very interesting dilemma. I would like to see there be some actual physical limit in terms of above ground level altitude, but that would be just too easy. And it's going to be different based on what is the private property. Is it 5 acres of field with nobody in it, or is it a 8,000 square foot plot of land which has your home and your pool and your backyard? I mean, there are differences. I mean, it's going to be very, very difficult to kind of decide on what this is. And then it's going to get even more difficult when the sensors on these UAS get better and better. I mean, right now at 200 feet, your resolution of what's down on the ground is probably not as good as it will be 5 years from now or even a year from now. So that changes everything, because how closely can you see detail from 200 feet now versus in the future?
Right.
So the laws that do come out are going to be, again, possibly challenged when the technology for filming gets much, much better, much more resolute, and people are going to get all up in arms about privacy once again.
Yes. So, and it is going to be interesting, and there can't be just one rule. And of course, if you own a skyscraper somewhere, do you own above the skyscraper? I mean, there's all kinds of permutations of this. And in the meantime, drone operators need to, be able to kind of sort out what they can and cannot do. Now, a little bit of this is mooted by the fact that the FAA doesn't allow you under a commercial Section 333 or Part 107, once that gets adopted, to fly over someone else's property without permission, right?
Yeah.
So
yeah.
that was perhaps in retrospect a very good foresight on behalf of the FAA to try and punt some of these issues down the road.
Yes. However, we still have recreational pilots flying that don't abide by Section 333 and will not be abiding by 107, because that's just for commercial users. So we still have that body of people that may be uneducated and may be flying and making it worse for everybody else, because they potentially may be flying uneducatedly and doing these things, which will bring everybody down.
Yeah. Now the tough question, Sarah. So, where do you see this going in terms of property owners and states and municipalities and the FAA and drone operators, as everyone now tries to sort out jurisdiction and rights? Where do you think this is heading over the next couple of years?
I'm seeing a lot of litigation in the future. I'm seeing a lot of conflicting cases between states, until we get some kind of a federal rule, a federal case law, or federal something that would basically quash everything else that's happening at a very lower level in courts.
Yeah, it does seem inevitable that this can only be sorted out in courts and by creating precedent that can allow people to understand, where the edges are, where the limits are, where the risk is. So, this is Drone Law Radio. We've really enjoyed having Sarah Nillson in today, and we thank you so much for joining us, Sarah.
Thank you for having me.
I hope you join us again soon, and we will see you next time on Drone Law Pro Radio.